Hamza.
Yes. Moro. I think that I have done justice to the matter beforehand already, even before Paul came into the studios. But you see, I agree that you are likely to think that when it comes to the forum that the Chief Justice and her lawyers decided to choose in this particular instance, the appropriate forum would have been the Supreme Court. But I have read through many of the concerns that she's raising, and it borders on also a measure of judicial review when it comes to the work of the Commission of Inquiry. And so I can understand the strategy behind his lawyer's decision to go to the High Court instead. Because remember that the High Court is still placed, was included with the legal authority of reference to the Supreme Court in terms of many of these cases. So the door in that regard would still be open for them to attempt to force an interpretation or push through an interpretation of Article 146 as to whether indeed there's a difference between the office of the Chief Justice and that of a Superior Court judge. I hold a firm position that in as much as we think that there's some kind of difference, one would have to be a Superior Court judge before you are made a Chief Justice of the Republic of Ghana. And if you look at Article 1461 that I read, it was quite clear on grounds of stated misbehavior that a Superior Court judge can be taken out of office on the basis of that particular Article 1461. And to the extent that the Chief Justice and the petitions that came against her had to do with her role as a justice of our Superior Court, I think that it is only fair for us to conclude by legal deduction that indeed you cannot continue to sit on the bench. And Moro, if you look at Article 128, the office of the Chief Justice, it makes the Chief Justice part of the Superior Court. If you look at our constitutional provisions, the Chief Justice is part of our Superior Court. So the Chief Justice sits on the Supreme Court. She's a member of the Court of Appeal per Article 1368. She's also a member of the High Court per Article 139, and also to a very large extent, a member of the Regional Tribunal. So you cannot have such a Superior Court judge sitting on all our Superior Courts, and yes, or being a member of our Superior Courts, and yes, still when she's taken out of office as Chief Justice of the Republic of Ghana, you still want her with the tag of stated misbehavior to continue to be a member of the Supreme Court of the Republic of Ghana. I'm struggling to understand how that can be done. But like he indicated, and on that score, I don't disagree with him. That is not a decision for me to make. It is a decision of the Supreme Court to determine whether indeed there should be a difference when it comes to the Superior Court Judge Torkornoo and that of Chief Justice Torkornoo as she then was, not long ago. So that determination undoubtedly will be made by the courts. And I wouldn't want to belabor that point. We'll leave it to the Supreme Court to determine. But based on the legal architecture, legal text that I am privy to have read, and our legal jurisprudence, I don't see why the Supreme Court will reach a different conclusion. And many of the cases you read, that inclination and direction have been given, including the decision that was read by Madiba Okran in the Frank Ajichum case, where he was emphatic that indeed, if you are a Supreme Court judge and you are taken out of office, or if you are a Chief Justice and you are taken out of office, it affects your role as a Supreme Court judge. So that is a decision for the Supreme Court to take, or the High Court, based on this power of reference, can refer the matter to the Supreme Court to make a determination on.
How about the argument he makes about entitlement to the how do you call it, the
Prima facie
case? Yes, that's the
I think I have listened to that debate also. Right. And in all honesty, the point I intend making on the matter is that, if my memory serves me right, I think that the Chief Justice now sacked still has a case before the Supreme Court, and we are all waiting for a substantive determination of that particular case that is before the Supreme Court. But she raised the issue of prima facie in that particular case as well.
Yeah.
And this is one caution I want to throw out.
Right.
Especially when it comes to the legal field. what may appear convincing and make sense to the ordinary man on the street may not be supported by any legal principle. And we have to be very careful. I listened to my brother Paul's rendition on the relevance of such a declaration or determination of prima facie being made available to the Chief Justice and the relevance of that when it comes to the dispensation of justice. And I was taken aback because of the limited appreciation, especially when it comes to judgments of this nature. And I'm going to read directly an aspect of the decision of Justice Amadou Tanko in that same case that was presented before the Supreme Court on the issue of the establishment of prima facie and the fact that it was not given to Madame Torkornoo. This is what Justice Tanko said in the ruling. The next ground on which the applicant invites the court to restrain the committee is that the prima facie determination was not judicious, as it was rendered without reasons. Are you following?
Yeah.
The concerns of Paul. I have cautioned myself against prejudicing the substantive relief sought in this action.
Right.
And he continues, however, it is not in doubt that the applicant herself has acknowledged the existence of a prima facie determination, however described.
Okay.
Because it was on the basis of that she decided to go and meet the commission of inquiry. And based on which she filed those cases at the Supreme Court. And that is what Justice Amadou is saying. It's insightful. However, it is not in doubt that the applicant herself has acknowledged the existence of a prima facie determination, however described. Whether the form and content of that determination render it a nullity due to the alleged absence of reasoning is a matter to be determined at the substantive hearing. So that case is pending before the Supreme Court. And he doesn't end there. He says, be that as it may, I am not oblivious to the jurisprudence from this court that a judgment rendered without reasons is by any means a judgment.
Hey. A judgment read without reason.
A judgment rendered without reasons is by any means a judgment.
Right.
And this is Justice Amadou speaking, a justice of the Supreme Court. Be that as it may, I am not oblivious to the substantive hearing. Be that as it may, I am, where's the reason? I am not oblivious to the jurisprudence from this court. Jurisprudence from this court. There's a litany of cases that support that assertion, that legal principle that Justice Amadou espoused in his judgment. And he says that a judgment rendered without reasons is by any means a judgment.
Right.
So the effect of this particular quotation from Justice Amadou is that, look, even if we agree that His Excellency President Mahama and the Council of State failed to give you reasons behind the determination of a prima facie case, it does not nullify the process. Because even in our jurisprudence, a judgment can be made without reasons. So you are not entitled as a matter of right to the report of the prima facie determination. You are not.
Paul says you go to court. He cites an example of taking somebody to court. You get to court and you don't tell the person why the person is in court.
And what do you mean by you are not told that the committee wrote to her?
Right.
His Excellency President Mahama, even before she appeared before the committee, gave her copies of the petition to respond to. Have you forgotten when she demanded same?
But would that be sufficient enough?
But these were the allegations against her. So she knew the allegations before her that was against her. Indeed, in this particular judgment, the Supreme Court held that based on her responses and her conduct, it was clear that she knew the charges against her. And that is a decision of the Supreme Court.
But Hamza, bear with me.
Mm-hmm.
When the presidency wrote to her, never mind the fact that she complained that she hadn't been told why, blah, blah, blah. When the president wrote to her and told her that, look, these are the allegations that have been made against you. She wrote back to the president. She gave her responses. And then the president obviously will ferry that to the Council of state, and then they'll look at it and say, well, based on her responses, she still has questions to answer. Now, based on the allegations and her responses to the allegations, they then arrive at a prima facie determination.
Yes.
Now, would you say that the fact that she's been told that these are the allegations that have been made against her, based on which she responded to those allegations, is sufficient enough to say that I know why I'm being asked I know why I am being asked to go and face a committee and respond to? Is that sufficient?
It should. It should suffice. And you see, Moro, let me explain. These were allegations that were leveled against her. She was given copies of the petition.
Yes.
She sat down, responded to every allegation on the petition. You understand?
Right.
Interestingly, the presidency, in consultation with Council of State, looked at her response as against the allegations raised in these petitions and concluded that she needed to answer more questions in relation to the allegations that were leveled against her. But this is one point that we are all missing. When you make a case in court and a prima facie determination is made, the one making that determination, because of information available to him or her at that material moment, may think that only ground A, allegation B can be supported.
Yeah.
And probably would think otherwise of some of the allegations. But because it is not a final judgment, there's still an avenue for deeper legal scrutiny to be applied. You do not just say that because I have made a determination in allegation A, B, and so let it slide, the others should go. It is only proper for you to sail same through to the Commission of Inquiry that is clothed with the constitutional responsibility of arriving at a final determination for the government to take action on.
All right.
For all you know, when that is done, and they conclude that, look, Madam Torkornoo, you have no questions to answer, she could have been allowed to go scot-free. But in this case, the Constitution is the members of the Commission in their wisdom felt that the allegations were grounded.
Okay.
And decided to advise His Excellency President Mahama in line with what they found out.
Right.
And like I have read out to you, the matter of the determination of the prima facie and its absence of a report sent to her is still before the Supreme Court. But even though we all acknowledge that it's still before the Supreme Court, Justice Amadou tells us that this is the position of the law.
Okay.
And it should be clear to any of us around this table that it shouldn't be difficult for us to anticipate the position of the law when it comes to the issue of the determination of the prima